Good afternoon, everyone. My name is John Cornwell. I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's program, which is part of our Sophisticated Employer webinar series that's sponsored by our Labor and Employment Law Practice Group. Under the Trump administration, the National Labor Relations Board appears to be shifting momentum back in favor of employers. So today's webinar will take a closer look at the board's rulings and case law that appears to have that pendulum swinging back toward employers. Joining us today to provide a detailed update are Plunkett Cooney Labor and Employment Law Practice Group members, Laura Dinon of our Petoskey, Michigan office, and Cindy Puricelli, who is in our Bloomfield Hills office. Before we get started, I'd like to take just a few minutes to provide you with some background about today's speakers and about our law firm. For those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest firms with about approximately 140 lawyers. We have offices in 7 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Plunkett Cooney's Employment Law Practice Group includes more than 20 attorneys who work in the areas of traditional labor law, human resources consulting, employment litigation, and workers' compensation. Our Sophisticated Employer webinar series is designed to help human resource professionals, risk managers, and business executives stay up to date on important legal issues and to provide HR best practices and to discuss trends in workforce management. Today's webinar is approved for 1.25 general recertification credit hours through the HR Recertification Institute and 1.25 professional development credits through SHRM. Following today's program, and typically within 2 business days, a certificate of completion will be emailed to each of you reflecting this credit. If you don't need CE credit, you can simply disregard the certificate. So now a bit about today's presenters. I'll start with Laura Dinon and throw it over to Cindy, who is going to be our first speaker. But Laura has over 30 years of experience advising employers. She's built a successful practice representing public and private sector employers of all sizes in northern Michigan. Her expertise includes traditional labor and all aspects of employment law, including exclusively defending employers in litigation and in administrative proceedings. Laura is a past president and the current secretary of the board of directors of the Northern Michigan Society of Human Resource Directors. With nearly 20 years of experience, Cindy Puricelli represents a variety of private and public sector employers as well in the areas of labor and employment law. She served for several years as an assistant corporation counsel in the City of Detroit's Law Department and the Labor and Employment section, and as a second deputy commissioner of the Detroit Fire Department. Today, Cindy's practice includes a variety of matters, including the defense of employment liability claims in state and federal court. Now for a few housekeeping notes about today's program. For the Q&A portion of our webinar, we're going to use our questions widget, which is on your GoToWebinar navigation display. So if you could, please take a moment now to locate that widget and feel free to enter questions as they occur to you during the program. At the end of the presentation, we're going to try to answer as many questions as possible. And I always like to mention this, but as you think about questions and enter them, think of them in a more of a general nature if you can. It's tough to get into specifics about any particular workplace, and I think you would agree with that. So we want to keep it kind of general if we can, and we'll take those questions at the end. Finally, I need to mention that today's session is being recorded and that the recording will be available on the event page of Plunkett Cooney's website, which is located at plunkettcooney.com. So feel free to share a link to that page with your colleagues after today's presentation, and they can view that recording. Thanks again for attending today's webinar. Now let's get things started and see what's new in employment law. Cindy, I think you're up first, so go ahead and take it away.
All right, thank you, John. Good morning, everyone. I want to start us off with the most basic of questions, and why does the NLRB matter? And it matters because they are an agency that is specifically tasked with interpreting the National Labor Relations Act, which includes the behavior of both unionized and non-unionized workers or of private employers. The decisions and rulings apply to private employers regardless of whether the employees are unionized or not. So if you're on the line and you have a non-unionized workforce, the decisions and opinions we are going to discuss today could still greatly impact your employment operations. Before I talk about recent changes, I want to remind everyone of some terminology that is considered the grounding force of the National Labor Relations Act, and that is protected concerted activity. Protected concerted activity includes, and it was worth putting this in so you can all see it, 2 or more employees addressing their employer about improving their pay, 2 or more employees discussing work-related issues beyond pay, such as safety concerns with each other, an employee speaking to an employer on behalf of 1 or more coworkers about improving workplace conditions. These are what we're going to talk about later, mandatory subjects of bargaining in the labor arena. So whether unionized or non-unionized, these activities are considered protected, and the employer cannot chill or restrain employees from engaging in these activities. Chill or restrain would include 1, making policies restricting employees from having such conversations or commenting on the employer's work conditions. 2, taking disciplinary action against employees for engaging in these conversations or activities, or any combination of the 2. So this definition, particularly, the 8 years under President Obama, had a rather expansive definition, meaning that you could simply find 2 employees having a conversation about their employment, and that would trigger protected concerted activity. However, the cases I'm going to talk about today limit this definition, and specifically the theme for the cases I'm going to talk about in the next few minutes is as follows. Griping is not a protected concerted activity. That's right, personal gripes are not protected. So let's start with Alstate maintenance. This case deals with workers outside of the airport at JFK Airport in New York. So I want everyone to imagine the last time you pulled up at DTW, workers approached your vehicle, they helped you with your luggage, they carried things for you, you gave them a nice tip. Or you might give them a tip after I tell you about this case. So in this case, those workers are called skycaps. And on this particular day, a group of skycaps were asked to assist with a VIP customer that was a soccer team and to be ready when the team pulled up. And one of the skycaps told the manager, well, we did this last year for them and we didn't get a good tip. And the manager, not being very pleased about that, told them, well, we expect you to still perform the service. A few minutes later, when the team arrived, the skycaps walked away from the customers and did not assist with the job. Although the facts of the case go on to explain that 3 of the 4 ultimately came back, not the guy that complained, they ultimately did receive a tip, but after the incident went to management, they were all terminated. So the question submitted to the board was whether the individual skycaps comment was concerted protected activity. And the board determined that the skycaps comment was mere griping. And they said, the fact that a statement is made at a meeting in a group setting or with other employees present will not automatically make that statement concerted activity. And the board articulated, this is your 2-part test. Did the individual employee statement to the supervisor or manager bring a truly group complaint? Or did the totality of the circumstances support a reasonable inference that in making the statement, the employee was seeking to initiate or prepare for group action? Here, the board determined that the skycaps individual comment was not for mutual aid or protection of other skycaps, where the employer had no bearing on how much skycaps received in tips. So in other words, the employer was not able to affect the amount of tips between the customer and the skycap. So if the employer did not have any control over what the skycap was complaining about, the amount in tips, the complaint could not be for mutual aid or protection within the employer's control. So your takeaway for this discussion is griping is not a protected activity solely because it is carried out in the presence of other employees and includes the use of a first-person plural pronoun. The test is the activity must be concerted and undertaken for the purpose of mutual aid or protection, and here the comments were neither. So in Quicken loans, everybody's going to like this case. So we got two mortgage bankers. I don't know if they thought the public restroom was private, but they're having a complaint session about a client. One declared that he had been trying to reach a client for over a week. The client should get in touch and stop wasting his effing time. The other employee said, "I understand why you're frustrated." The employees were terminated because there was a supervisor in the bathroom stall. So the question for the board was whether the second employee that merely said, "Well, I agree," or "I understand," he was expressing sympathy, was he engaged in protected concerted activity? The judge on this case, and that's before they get to the board, found that the two employees were engaged in concerted activity where one was complaining about an employer process of client contact and the second employee was vocalizing his support. However, on appeal, the board found that the two employees were not engaged in protected activity where one was complaining about something that only affected himself and the second employee was expressing an understanding of an individual frustration. So ultimately, the two employees' complaint and response amounted to griping about an issue with a client in a public restroom on the employer's premises. So our takeaway here, again, where an employee is expressing a personal complaint, there is no protected activity. The board is now classifying this as griping. And if you're asking yourself, well, the second guy, all he said was, "I understand," why would he be terminated? There's always lots of underlying facts. Turns out he had a spotty work history, and the employer asked him outright about the conversation in the bathroom. He denied the whole incident, and he waited until they said, "Well, you're being fired," and he said, no, yes, I knew about that, and I didn't really mean anything by it, and so he was still ultimately terminated. The last case we are going to look at for this section arises out of action taken by General Motors. It is an advice memorandum, and I like this particular case because I gleaned some information about social media postings that everyone should be interested in addition to discussion about protected activity. So the issue here is whether General Motors improperly suspended an employee for a profane social media post where its social media policy itself was overbroad and interfered with employee rights. Said another way, the board's opinion in this case ultimately was that GM's social media policy chilled employees' rights, but that it was ultimately entitled to suspend an employee who posted an inappropriate and profane rant on behalf of himself as an individual. So this involved GM's site in Lansing. Due to inclement weather, they had decided to cancel a third shift, but hold the second shift over. The subject employee was on the second shift. He went to talk to management about it. He was upset about the holdover. Later on that night, a post appeared on the company Facebook page discussing the issue with several employees taking exception with the way in which the shifts were managed. The original employee that complained became upset with another employee that agreed with how management dealt with the situation and posted, "Who the F do you think you are?" The employee removed the post. However, the next day he was called into his shift leader's office and confronted about the posting. He was admonished with no further action, disciplinary action. However, later that day, he goes on to make the following post. It has come to my attention that someone did not like my foul language in my postings last week and decided to report me. Well, I believe I am still an American that has this thing called the right to free speech. Whenever you see this from an employee, you know they're about to say something inappropriate that they could be disciplined for. If you are offended at foul language, then you have every right not to read what I write. So the person who reported me kissed my expletive. The employee was, of course, then suspended. GM's position was that the employee was warned about his inappropriate language the previous day and still did it again the next day. The board stated in the opinion, there is no violation of the act where the conduct for which the employee is disciplined is wholly distinct from activity that falls within the ambit of Section 7. So in English, the board explained that comments made solely by and on behalf of the employee himself are not concerted. So here, the employee is posting on the employer's Facebook page that resulted in his 3-day suspension. He was expressing personal anger with a coworker for reporting his posts that were made solely on his behalf and had gotten away from whether or not he was upset about the shift change that occurred in the plant setting. So what are our takeaways? Griping is not protected. Individual complaints are not protected. The mere presence of another employee will not make an action concerted activity. And an overly broad policy can still be actionable where the underlying conduct in and of itself is not protected activity. Laura is now going to discuss some implications for independent contractors.
Thanks, Sydney. The NLRB recently revised its test for determining employee status, and they've made it easier for some employers to stop workers from forming unions or bringing federal labor complaints. The case that reversed the prior decisions is SuperShuttle DFW, Inc. And in that case, the SuperShuttle franchisees operated shared ride vans, and the board determined that they were excluded from the Act's coverage as independent contractors, and so they didn't have a right to form a union. The board applied the common law test, and the majority found that the franchisees' ownership of the principal instrumentality of their work, the van, the method of their compensation, and their significant control over their daily work schedules and working conditions provided the franchisees with significant entrepreneurial opportunity. And so the majority found that those factors, combined with the absence of supervision and the parties' understanding that the franchisees were independent contractors, outweighed the factors supporting employee status. And if you're an independent contractor, you can't form a union. In the dissenting opinion, the author noted that the federal government was backtracking on who's an employee and who's an independent contractor, and that is pretty significant because for many years now, in every aspect of government regulation, from the IRS to unemployment agencies, the trend has been to determine that employees are not independent contractors, but here we have the NLRB expanding the definition of independent contractor. Sydney, I think you're taking the next topic.
Thanks, Laura. Now we're going to talk about contract coverage standard. This is always a good one. So in this case, the issue is, what standards should the board apply to determine whether a collective bargaining agreement grants the employer the right to exercise unilateral action if stated in the CBA? Unilateral action is always one of those phrases that sends the antenna up, because in the realm of labor law, people don't like unilateral action. You certainly don't want to see it in writing, and you certainly don't want the employer to have it. But that's what this case is about. So in other words, if the contract itself says an employer can take unilateral action and the union or employees dispute that, whether at the board or through their own grievance process, what standard applies? The board, in deciding this issue, has found that the language of the contract itself, or quote unquote contract coverage standard, will apply. So the facts in this case were that the transportation company implemented 10 policies affecting unit employees' terms and conditions of employment, sought union input, adopted some of the union's input, but then went forward with implementation. The union contended that inappropriate unilateral changes were made that amended the underlying CBA, and that the employer was required to bargain to impasse. Under the first category of changes, the board recognized in Section 885D require employers to bargain with the union, and that's what I was talking about earlier. Mandatory subjects of bargaining are those that deal with wages, hours, and other terms of conditions of employment. A nuanced question then becomes whether the union can be held to have waived the right to bargain on any of these so-called mandatory subjects of bargaining, and the answer will be yes if the contract coverage standard applies. It used to be that the union would have to waive its rights. So a waiver would occur when a union knowingly and voluntarily relinquishes its rights to bargain about a matter. But where the matter is covered by a collective bargaining agreement, the union has exercised its bargaining rights, and the question of waiver is irrelevant. So what we mean by that is if the parties have the opportunity to sit down and agree to language that unmistakably gives the employer the right to act unilaterally, the union cannot then come back and contend it did not waive that very right. So in fact, if the union has exercised its right to bargain and given away a particular right, as reflected in the actual language of the CBA, then this is called the contract coverage test. This is a particularly exciting opinion because it assumes and demands that the parties not leave anything on the table when negotiating. And in some cases that I've seen over the years, unions and employers will put in ambiguous language on purpose so that they have something to argue about when they get to a labor arbitrator. However, what the board is saying in this case is they want to avoid arbitrary interpretations. So the board explained that contract coverage encourages employers and unions to make an effort to foresee potential labor management relation issues and resolve those issues in as comprehensive a manner as practical. Moreover, by ensuring all provisions of the parties' agreement are given effect, the contract coverage test will end the board's practice of selectively applying exacting scrutiny only to those provisions of a labor contract that vest in the employer a right to act unilaterally. So now, under the new test, the parties themselves are in control of negotiating the parameters of unilateral employment action. If the union doesn't want it to be there, then they won't put it in there during the negotiation. So what are our takeaways? The language of the CBA controls. So, for instance, you sit down with the union, your new CBA says on certain policies, let's say, switching shifts. And that is the plain language of the contract. The employer has the right to switch shifts. The employer would then not have to show a waiver, for example, by stating that usually what happens in a factual dispute is the union will say, you don't have a right to do that. The employer will say, well, you waived it because not only is it in our language, but I changed some of the shifts and you didn't show any opposition to it, but that's still getting into a factual dispute. So the board is doing away with that, and they're saying if it's in the collective bargaining agreement itself, that they will enforce that action in that language. Laura is now going to talk about arbitration.
Thanks, Sydney. In Cordua Restaurants, which was a decision from the NLRB in the fall of 2019, the employer the employees of this restaurant system voted in a union. In response to that vote, the employer drafted mandatory arbitration agreements and told their employees that if they didn't sign these, they were going to be fired. So the board considered these issues, which were new, and held that the NLRA, the National Labor Relations Act, does not prohibit employers from drafting mandatory arbitration agreements in response to employees forming a bargaining unit or opting into collective action. And it also does not prohibit employers from threatening employees with discharge for failing to sign these mandatory arbitration agreements. And this is really an amazing decision. It's very pro-business and I don't know, employee is not really the word, but this is a big deal. So if you're in a situation where you're not unionized, your employees decide to vote in a union, you can force them to agree to arbitration rather than running to the NLRB to enforce the terms of the contract if they sign these mandatory arbitration agreements. And if they don't agree to, they can be discharged, which ultimately really is a discharge for union activity. So I think this is really surprising, but know that it's out there. And as part of it, that decision, there was a discussion of the case Epic Systems versus Lewis, and the NLRB held that employers can force workers to waive the right to file class actions and instead require them to go through individual arbitrations if they think their rights have been violated. You probably hear a lot about class actions these days. The benefit to the employees is that they individually might not have a very valuable claim, and so it'd be really hard to get an attorney to take their case, whereas if they all join together, the collective amount that might be at issue would be substantial enough to get an attorney to take the case. And class actions are extremely expensive for employers to defend. And so that was the holding in Epic Systems. Employers could force arbitration and require employees to waive the right to file these class actions. And Cordua Restaurants goes even a step further. They can fire them if they won't agree to it. The next topic is on the same wavelength, but a little different. So if you have employees' grievances that have gone to arbitration, they used to be able to appeal some of those if they concern discipline or discharge that allegedly violated the NLRA. They could take it to the NLRB. The NLRB has returned to its traditional standard for post-arbitration deferral. And this means that they will defer to the arbitrator's decision and not take it on as a case under the NLRB if the arbitration proceedings appeared to have been fair and regular, that all the parties had agreed to be bound by arbitration, i.e. the union and the employer, and the arbitrator considered the unfair labor practice issue, and the arbitrator's decision is not clearly repugnant to the act. This is a very good case for employers also. It was United Parcel Service that was handed down in December of 2019, so a very recent case. And moving on from arbitration, Sydney's going to take the next topic of profane and offensive outbursts.
Everybody's favorite topic. So I love this topic because this gets into the invisible rule I call the I can say whatever I want when I'm the union guy. So I actually had an employee once that if he was coming in to speak to management, he would put on a hat that said, I'm representing the union. And by that, I mean just wearing a hat that had his union insignia on it. So why is this important? Because we know union officials, they get excited, they start cursing, and they say it's all protected because I'm acting in the interest of my bargaining agreement. I can say and do whatever I want to management while I'm the union guy. So the rules we're going to look at today address this very instance of employees using profane language, whether verbally, online, social media posts, whatever the medium is, when is it appropriate? So recently, in September of 2019, the NLRB decided to solicit comments on how it should rule on profane outbursts during labor discussions, negotiations, picketing, line activities, whatever it may be. When will it be considered protected concerted activity? Can an employee act so inappropriately that even if he's a union official, that would be taken outside the protection of the National Labor Relations Act? So it sounds like the board, in reviewing the three cases that we're going to look at today, they want to be able to draw a distinction between the phrase we all know and love, shop talk, and inappropriate, profane, and inexcusable language or behavior in the workplace. And this came about through another General Motors case, poor General Motors, in which a worker filed a board complaint after he was suspended for repeatedly directing the F word at his supervisor. So before rendering a decision, the board has asked for input to set a standard based on these next three cases: Plaza Auto Center, Pier 60, and Cooper Tire. And what you're going to see is each individual case has more egregious facts than the last, and a different standard and different tests about how the outcome came to be. And while these decisions aren't good for employers, what is good is that the board seems uncomfortable with leaving these cases here and leaving them as the standard for how to decide cases. And so let's go through these, and I'll tell you about all of the factors and standards that are part of the cases. So in Plaza Auto Center, this is a non-unionized case. A 2-month salesman at the auto company was fired after he engaged in several conversations about pay, benefits, and break times with other employees. However, the issue came to a head when he sold a vehicle that was considered to be a flat rate of about $1,000 to $2,000, and he was provided a nifty check for $150. Well, he thought that was unfair. And then in another meeting, the manager brought all the employees together and said, hey, one of the cars outside has been damaged. If you all don't come forward or somebody doesn't come forward, I'm going to dock everyone's pay to cover the cost. Well, the salesman said, well, that's not fair, and you can't do that. And furthermore, you have not been paying us minimum wage. So the salesman and the manager decided to have a private meeting in which the manager told the salesman he was complaining way too much, asking way too many questions. And the manager went on to say, in essence, that if he, the salesman, didn't like it, he need not work there anymore. At which point the employee called the manager an effing crook and an a-hole. And the employee also told the manager, now we're getting into high school realm, nobody liked him, he was stupid, and everybody talked about him behind his back. So naturally, the manager told him he was fired and to get out. The standard the board considered in this case was whether the salesman's conduct was menacing, physically aggressive, or belligerent. Finding that he wasn't any of those things when he verbally attacked his boss, the board turned to determining whether the salesman's outburst was still protected under the National Labor Relations Act. The board relied on the test set forth in a case called Atlantic Steel, which set forth a 4-factor test. Place of the discussion, the subject matter of the discussion, the nature of the employee's outburst, and whether the outburst was in any way provoked by the employer's underlying unfair labor practice. So here, although the salesman had personally verbally attacked the manager, the board concluded that the other three factors weighed in favor of the salesman because he had been provoked by the manager's threat to termination in responses to what the salesman and other employees perceived to be an unfair labor practice. For example, not paying the minimum wage and docking employee pay. The court explained that the outburst occurred during a discussion of key working conditions in a manager's office outside the presence of other employees and was a spontaneous reaction to the respondent's serious, unlawful provocations by an employee who had never previously engaged in similar misconduct. The Atlantic Steel case, and this is where the concept of shop talk comes from, was decided under the premise that the realities of industrial life and the fact that disputes over wages, hours, and working conditions are among those disputes most likely to engender ill feelings and strong responses. So realistically then, when we talk about traditional union shops, Ford, GM, their suppliers, we would give little thought to a non-unionized auto shop getting this type of protection, but it exists, and that's why this case is important. So let's talk about the next case. Pier 60. In Pier 60, the board determined that this particular employee's conduct was at the outer bounds of protected union-related comments, but that his conduct was not so opprobrious as to find he would not be protected. Now, I have to tell you, I'm like a professional reader, and I had to look this word up. It means expressing scorn or criticism. Write that one down. It's a good one, opprobrious. So let's see whether or not this employee was opprobrious. The employee wrote on Facebook, "Bob is such a nasty mother effer. Don't know how to talk to people. F his mother and his entire effing family. What a loser. Vote yes for the union." Okay, so just reading this, you might be thinking, surely this is the very definition of opprobrious, including some other things like profane, insubordinate, belligerent, rude, and anything else you can think of. How could the board possibly rule in favor of this guy? But it turns out that all of this was happening inside the context of a union certification election. This was a post that went up 2 days prior before the union was to be voted into this employer's shop. So nobody was happy. The employees aren't happy. The employer isn't happy. The employer is doing things to provoke the employees. They're in a service industry, so don't look at the customers. Don't chit-chat with each other. And it was all to keep them from talking about whether or not they wanted to vote the union in. So during one of the serving events, one of the managers was upset with the employees, given the circumstances of everything that was going on. And Perez, the 13-year employee that had been sort of leading the charge, he became angry back. Somebody sent him on a break. He left the employer's premises and went and made this Facebook post. But I don't really think just the certification and the circumstances is what drove this case. I think what ended up driving this case, and it's a really interesting read, is the judge on the case said, quote, "Vulgar language was rife in this workplace among managers and employees," unquote. So what does that mean? Management was known to curse at the employees, scream profanities at them, "You guys are effing stupid," call the employees a-holes, and even use racial epithets, think Perez, "You effing little Mexican." So now we see an entire picture where it sounds like the entire workplace is out of control and fraught with bad behavior, which is likely why the employees were seeking to organize. So it's no longer surprising that the board would side with the employee, but we need to find out what the legal reasoning was. So unlike the neatly packaged four-prong test that we saw in the Plaza case, this case ended up with 9 different factors that you see listed there. So was there any anti-union hostility? Was the employee provoked? Was the employee acting impulsively or deliberately? Where did the Facebook post happen? Subject matter of the post, the nature of the post, whether the employer considered language similar to that used by the employee to be offensive. How could they? They were also using it. Whether the employer maintained a specific rule prohibiting the language at issue. They couldn't possibly. Whether the discipline imposed upon the employee was typical of that imposed for similar violations or disproportionate to his offense. Obviously not in this case. So spelled out in this manner, the decision had to go in the employee's favor. The board agreed with the underlying judge's findings that all of the factors had to go against the employer, where the employer engaged in unfair labor practices, the employer was found to have provoked his conduct, that the employee was clearly provoked following frustration and months of disrespect leading up to the certification process itself, that he stepped away, the employee did, and posted the Facebook comments while he was on a break and not inside of the facility. His comments echoed complaints about management that reflected all of the employees' protected concerted activity. The board also echoed the sentiment of the court that clearly the employer, and again, I really think this is what the case turns on, the employer tolerated and allowed management to use profane and offensive language in the workplace. We do not find Perez's use of profanity to be qualitatively different from profanity regularly tolerated by the employer. So for factors 8 and 9, the board concluded that there was no evidence that any employee had ever been discharged for the use of profanity or other offensive language. So it's our takeaway. That's a lot. But to me, it all boils down to this. If you want a rule to stick in the workplace, the managers have to abide by it as well. Also, all's fair during election season. Management has to be in control. Management has to be looking for a way to cool passion, not inflame it. Particularly when you know your entire workforce is against you. On the other hand, what I'm seeing is that the board would like to elect one test or one unified standard for what is appropriate in these lines of cases because it's too unwieldy to have individualistic determinations made for each case. So that being said, let's look at the last case, which articulates even another set of factors. So Cooper Tire. This is a case involving a classic labor situation. Everybody's angry. They're in the middle of a contract negotiation. Everything's broken down. The contract has expired. The company wants to keep operating. And so now we've got an angry picket line. The employer is bringing in replacement workers, and you know all hell's going to break loose. So the issue in this case is whether or not racial epithets that are thrown out from a picket line, whether the employee that made those comments could be terminated. So in addition to the usual scab remarks and cursing and jabbing, one union employee yelled at Black replacement workers, "Hey, did you bring enough KFC for everyone?" Or, "Hey, anybody smell that? I smell fried chicken and watermelon." The case initially went to arbitration, and the arbitrator found that the use of racial slurs on the picket line increased the possibility that verbal exchanges could escalate into violence. However, the board used a different test, again focusing on threats. A striker's or picketer's use of even the most vile language and/or gestures standing alone does not forfeit the protection of the act so long as those actions do not constitute a threat. But this this couldn't be more subjective, as whether a replacement worker felt threatened is in that person's mind. So how can the board give that kind of standard? How can we follow that? So the board, went on to explain further that although the employees' KFC and fried chicken comments were racist, offensive, they were not violent in nature and did not contain any overt or implied threats to replacement workers or their property. So what is our takeaway here? You see, I said, what's positive here for the employer? But what I think is the fact that the board is asking for comments and briefs on these matters is significant. To me, it shows the board is clearly uncomfortable with two things. One, the lack of a single standard in these cases, and two, the egregious nature of these cases in and of themselves. This is good for employers because the board plans to articulate a single standard that will apply to all cases, and a new standard should be espoused that employers will know and be able to follow. So you can check back on our employment blog, and we will definitely follow up on these lines of cases. Laura is now going to discuss limiting access to employer property.
Thanks, Sydney. An interesting new case, Kroger Limited Partnership, Mid-Atlantic, and United Food and Commercial Workers Union. The NLRB recently held that managers at a Kroger supermarket in Virginia who called the police and asked them to remove union protesters from their property, specifically a shared shopping center parking lot, were not in violation of the NLRA. The court reasoned that protest and boycott activities are not sufficiently similar in nature to charitable, civic, or commercial activities to warrant a finding of discrimination based on disparate treatment of such conduct, regardless of the amount of charitable, civic, or commercial activities permitted. You might be familiar with this issue in the context of prohibiting solicitation in your workplace. A lot of employers have policies that say employees can't solicit coworkers either at all or during working time on their premises, and those policies sprung up in an attempt by a lot of employers to keep unions out because they didn't want coworkers soliciting on behalf of unions in the workplace. And so this is not even in the workplace, it's in a shared shopping center parking lot, and the NLRB said it was okay for the employer to kick the union protesters and people urging boycotting out. So that's, again, a very favorable employer decision. The next topic I think is of interest to most, if not all, employers. In a recent case, the NLRB overruled a prior case and determined that employers have the right to control the use of their email equipment as long as they don't discriminate against union or other protected concerted communications. For years, we've had to be really careful in drafting email and IT policies in an effort not to infringe upon the employer's Section 7 rights, which are the rights that allow them to discuss their dissatisfaction with their coworkers and their rights to organize. So the new case is Caesars Entertainment, DBA Rio All Suites Hotel and Casino, and the issue had previously been decided in Purple Communications in 2014. In Purple Communications, the board held that employees who had been given access to the employer's email system for work-related purposes had a presumptive right to use that system on non-working time for communications protected by Section 7 of the NLRA. In Caesars Entertainment, the board overruled Purple Communications and held that employees do not have a statutory right to use their employer's email or other information technology resources to engage in non-work-related communications. They specifically held that employers have the right to control the use of their equipment, including their email and other IT systems, and they can lawfully exercise that right to restrict the users to which those systems are put, provided that the employer does not discriminate against union or other protected concerted communications. So employers can say that employees can't do anything personal on any of the email or IT systems, but they cannot say you can, do your shopping, you can email your mother, but you cannot do anything that would restrict union type activities or organizing activities. It's either basically an all or nothing restriction. And this decision has an exception for circumstances where the use of employer-provided email is the only reasonable means for employees to communicate with one another on non-working time during the day. So if they're maybe in different locations, or I'm not sure exactly the circumstance that would apply to, but they left an out there so that they can find some restrictions still prohibited by the NLRA. But in general, the employer can limit the use of their equipment for non-work related purposes. And Sydney and I tried to hit a broad range of things. So some of these topics are pretty short. The next one we're going to talk about is confidentiality in investigations. The NLRB just overturned a 2015 decision, which was Banner Estrella Medical Center. And that case had required employers to prove on a case-by-case basis that the integrity of an investigation would be compromised without confidentiality. And many times when an employer has an incident in the workplace, a complaint, they want to do an investigation, and the best way to do that is to interview all the employees who know or may know of facts relevant to the investigation, but they don't want the employees talking to each other. They want an independent recollection from each individual employee, and they will warn them, don't talk about this, don't talk about the fact that we're investigating this, don't talk to your coworkers, basically complete confidentiality. Well, in Banner, the board had determined that blanket prohibition was illegal or in violation of the NLRA, but if an employer wanted to do it, they could prove it in individual cases that there was a real reason why that had to happen in that case, and they could they could require confidentiality. In this new case, which again came out in December of 2019, the board's been really active lately, which is one of the reasons we wanted to do this seminar. In Apogee Retail LLC, the board determined that investigative confidentiality rules limited to the duration of the investigation are generally lawful. Since the rule at issue in the Apogee Retail case did not limit confidentiality to the duration of the investigation, the case was remanded for further consideration. So in other words, the Apogee case, they said you can never talk about it, and the board found that that might be an illegal restriction, but in general, they could have said, you have to keep this confidential until we conclude our investigation and reach a conclusion. And if they had limited to that, by overruling Banner, the employer can require confidentiality from their witnesses when they are doing an investigation. And the next topic is, I think, of great interest. At least I come across this frequently and have for years, when employers are trying to craft a handbook and acceptable policies that don't violate the NLRA. The NLRB has taken the position for years that social media policies and confidentiality policies are violations of the Act. And so I want to spend a little bit of time on this case, and hopefully you'll get some good takeaways from it. The case is Coastal Industries, Inc., DBA Coastal Shower Doors. The employer has a handbook that had several rules that their employees claimed were unlawfully overbroad. They had rules requiring employees to refrain from certain inappropriate behavior, which included unbusinesslike conduct, creating discord, obtaining unauthorized confidential information, and soliciting not in good taste. They had a rule that, or a confidentiality policy that stated that all information retained or generated by the employer was confidential. Another challenged policy was an electronic assets policy that forbid disparaging language. A challenged policy was the social media policy that banned connecting to social media on the employer's electronics, banned posting derogatory information, and banned handing out the employer's telephone number. I think that's employee, sorry. And finally, a cell phone policy that banned all use of cell phones during working hours. So the NLRB went through each of these policies, and I'm going to try to go through them quickly with you. The first one, obtaining unauthorized confidential information pertaining to clients or employees, was determined to be a lawful rule. The rule prohibiting disclosure of customer information raises no issues, and they concluded that the general prohibition regarding obtaining unauthorized confidential information pertaining to employees is lawful. The next one, rude, discourteous, or unbusinesslike behavior, creating a disturbance on company premises, or creating discord with clients or fellow employees, was determined to be a civility policy and a disruptive behavior policy. And the board determined that, I believe, they were both lawful. They said that while protective concerted activity may involve criticism of fellow employees or supervisors, the requirement that such criticism remain civil does not unduly burden the core right to criticize. So you can criticize your coworkers or your employer, but you have to do it civilly. And they also, as part of that, determined that employers have significant business interest in maintaining civility rules. The disruptive behavior rules are also usually lawful. Employers have a right to ban roughhousing, fighting, dangerous activities, and other bad behavior. And they didn't feel that employees would interpret this rule as inhibiting their Section 7 rights. The next one was soliciting, collecting money, or distributing bills or pamphlets on company property by employees during non-working time. And they allowed it as long as the activity was in good taste. And so giving it the good taste qualifier made the policy limiting solicitation and distribution lawful. And that's kind of tied in with the comment on the protest in the parking lot. So because the restriction was to solicit or distribute only in good taste, it's not unlawful. The next one was unbusinesslike conduct on or off company premises, which adversely affected the company's services, property, reputation, or goodwill in the community, or interfere with work. The board again determined that this rule was lawful. They said that it comprised two different rules, an on-duty conduct policy and an off-duty, off-premises conduct policy, and that the vast majority of the activity covered by the rule was unprotected, and therefore it's lawful. They pointed out that employers have a significant interest in maintaining productivity and ensuring that an employee's conduct does not affect his or her job performance or others' job performance. The restriction on all information gathered by, retained, or generated by the company is confidential. There shall be no disclosure of any confidential information to anyone outside the company without the appropriate authorization. And then the employer tacked on, nothing in this policy is intended to infringe upon employee rights under Section 7 of the NLRA. They found that this rule was unlawfully overbroad because clearly employee wage rates, employment policies, handbook rules, and virtually all other terms and conditions of employment are information generated and retained by the employer, but they strike right at the core of Section 7 rights. So those are things that would not be confidential information because the employees have a right under Section 7 to disseminate and discuss it. And they also went on to talk about the tack-on of the Section 7 disclaimer, and they said that it wasn't enough to render the rule lawful. Sometimes in certain circumstances, you can clarify the scope of an otherwise ambiguous and unlawful rule with that language, but the savings clause here did not in any way indicate that the employees have the right to discuss wages or working conditions, and employees don't necessarily know what their rights are under the NLRA. The next one dealt with disparaging, abusive, profane, or offensive language, and any illegal activities, and it forbids, such as piracy, extortion, blackmail, copyright infringement. All of them were forbidden under the rule, and they found that this rule was a combination of civility policy and on-duty misconduct policies, and was a lawful rule. A rule that stated company electronic assets may not be used to access social media accounts was not unlawful. Employees should refrain from posting derogatory information about the company on any social media sites and proceed with any grievances or complaints through the normal channels was unlawful. It was overbroad, and the general rule requiring them to bring their complaints to the employer is unlawful. It's an independent violation of the Act. A rule prohibiting employees from posting statements, photographs, video, or audio that reasonably could be viewed as disparaging to employees was lawful. The employer can maintain rules demanding civility from its employees, which includes not disparaging fellow employees. These are all rules that over the last 10 or 15 years, this is quite a turnaround, is what I'll say. They have basically found all of these types of things to be violations of the Act. So this memorandum is a really big deal. A prohibition against posting to any online forums providing any company telephone number or extension was found to be partially lawful and partially not lawful. The ban on providing the employer's telephone numbers was unlawful. The self-identification requirement was lawful. It went on to say that if you're going to be on a site, you have to say you don't represent the company. And then This one was interesting. The use of personal cell phones or other mobile devices was prohibited during working hours for personal use, including phone calls, texting, and downloading of web content. This was found to be unlawful. They said that employees have a right to engage in Section 7 communications during non-work times, such as break and lunch. They would reasonably read this rule to prohibit cell phone use during those times, and therefore the rule was unlawful. So that's a really big deal, and if you want more information on that, you can find it. Google Coastal Industries, Inc. It's an advice memorandum from August of 2018. So I kind of have cruised through the slides on this topic, John, by being much more specific. So we can move on to questions, I think, at this point.
Okay, great. Thanks for that. It was a ton of information. So I'm sure that folks are trying to digest it all. So time has come for Q&A, and I just want to remind everybody, if you would like to ask a question, go ahead and type it into the questions widget on our display right now for GoToWebinar, and I'll try to read those off. We have one right now that is asking about the GM case that was covered earlier, and the question is, was that post made directly on the company site or the person's personal Facebook page, and would the outcome of the discipline change if it was on his personal page, if it was indeed put on the company page?
Okay, well, that was my case. So in looking at the advice memorandum to General Motors, which I'm going to post at the end of this webinar so that everyone can read through it, that posting was actually made on the company's website. But if you remember, what I said was that the NLRB decided that the General Motors policy was too overbroad. And so when I post the case, it's going to give you a roadmap to all of the reasons why that policy was overbroad. I can think of a couple that come to mind that made me chuckle. One said, if you're in doubt about something that you're going to post about on Facebook on the company's webpage, please confer with the general counsel or management before posting. Obviously, that would definitely chill Section 7 rights. And it actually had in the policy itself, be careful and hesitant about friending coworkers. So absolutely that goes against Section 7 rights. So let me answer your question though. No, because the employer did have a right to discipline for profane statements. I don't think the outcome would have been any different.
Okay. Just a reminder, I don't see any other questions, so now's the time. Type them in. We'll read them real quick. Otherwise, we're going to move on and wrap up for today. And I don't see anything else coming in. So what we'll do is move on to the end of the program.
And John, this is Laura.
Somebody just told me.
I'm going to also post this Coastal Industries Advice Memorandum because I think it's going to be very useful for employers. So we'll post this also.
Oh, it's two more questions also popped up here. So give me a second and I will try to get those up here. So the next question is, can you elaborate on or provide the best source to view the rules of the confidentiality during investigations?
Well, the case is, sorry, I have my stuff spread all over here. Yeah, I would think Apogee Retail is the best case, and let me see if I can give you a site. It is APOGEE Retail LLC, DBA Unique Thrift Store. It's 368 NLRB number 144, and it's a 2019 decision. And they go through, Apogee Retail goes through the banner medical center case and actually goes back to the Boeing case. So I think that would be a great starting point.
Okay, great. We'll try to post these cases out again on the event pages. There's an opportunity for us down at the bottom of the page to post the cases, actual links to the cases. So what I'm going to recommend at this point is, I know that we covered a ton of territory, and those posts can be made later today, hopefully. So if you go to our event page for Winds of Change, at the very bottom, you're going to see our slide deck. We'll eventually have and I'm going to cover this in a second, our recording of the program, and then we'll have those. We'll include those links so that we get you to that information. There was one question here about cell phones during working hours. I'm not sure exactly what that means. It's just asking how about cell phones during working hours. I don't know if we can say much more about that, Laura.
Yeah. What the general rule is that you can ban your employees from having their cell phones on them or in use, except during lunch and breaks. So depending on the circumstances, there's also cases out there dealing with cell phone use from the aspect of stealing trade secrets. Manufacturers don't want cameras in their workplaces, and so you can restrict them to keeping them in the locker room or taking them when they come into work and go onto the plant floor, sit down at their computer, whatever it is. But when they're on their own time, even if it falls during the working day, they have to be allowed access to their cell phone. But they, for instance, don't have to be allowed to access it if they take a break on the plant floor and you have a policy that prohibits it more based on the camera aspects of the phone. That would probably still be legal. If it was simply to prohibit them from doing anything with it, texting, talking to coworkers who are also on a break, that might violate. But basically, on their own time during the working day, they have to be allowed to use them. Otherwise, the employer can ban them.
Perfect. Thanks for that. Okay, so we're going to advance through to a final couple slides here. Just want to make sure you know that we're going to, as always, ask you to help us out with a survey. It's very brief, and I know that we always go through the feedback that we get in terms of topics as well, and try to really deliver the topics that you want us to cover. So if you could, please take care of that for us, and that'll help us immensely as we go forward in the year. Just a reminder, we're offering the CE credit. Just give us a couple, working days to get it to you. I know some people really want to get their confirmations and be able to move on to the next training event, but we need about a couple days to get that to you. So look for it in your email, and you can disregard if it's not needed. The other thing that we always like to ask is, if you like this content and you have others in your organization who could benefit from it, please share it. All you need to do is go to our event page and share that link. There are tools that allow you to share it quickly. And again, we'll post those cases that we talked about at the bottom of this page, hopefully later today. We also couldn't leave without promoting our next upcoming event. And we have a fun one there for you, for those that are in Metro Detroit in particular. On February 7th, in kind of as a salute to Valentine's Day, we're having fun. And we're going to have a seminar at the Troy Marriott called Be My Valentine or Else. And as you can see, it's got a bit of a spooky bent to it, so hopefully you can join us there. There's no charge for this, and we'd love to see you and your colleagues there, so please share this around as well. And as Sydney had mentioned before, we have our blog, the Sophisticated Employer blog. We post a ton of information there that we hope you will follow, like, and share. Always love that when you do it, so please, if you can. I also wanted to say, one more thing. I wanted to say one more thing about this. I think Laura and Sydney, you guys are both going to be speaking at this particular seminar, right?
Right. So I want everybody to know that it's going to be about employee relationships and when they go bad. And they always go bad in the workplace, right? So when is an investigation warranted? What is HR's role? What are the pitfalls of taking disciplinary action against one employee in a relationship but not the other? And all the mental health issues and fallouts that come from inappropriate relationships in the workplace.
It's going to be a fun one. It's going to be a fun one. Okay, that's it. We took too much of your time already. We're a couple minutes over, so we apologize. But thanks again for being with us. We really appreciate it. Have a great rest of the day.